Good evening. Welcome back to The Particulars. Everything you are about to hear was fact-checked and verified through today's court adjournment. For day 19 in the Clancy trial, we cross-checked our detailed live notes against the court video's auto-generated transcript. It is not a certified transcript, however, so it will paraphrase where the machine wording is uncertain. We're investigators teaching from the public record, our opinion, our analysis, not legal advice.
Tonight, three things are moving at once. In Massachusetts, the Lindsay Clancy murder trial is in its final stretch. Dr. Avram Mack finished his testimony. Dr. Kurt Heilbrun gave direct testimony. Heilbrun gave direct testimony, but had not yet reached his ultimate criminal responsibility conclusion. Then the day ended with an objection, a mistrial motion, a rebuke from the bench, a curative instruction, and the jury sent home. We have day 19 through adjournment.
In Las Vegas, week 2 of Nevada versus Dwayne Keefe D. Davis opened this morning. The jury heard from more Compton witnesses today. But tonight, before we get to day 6, we are doing the breakdown we promised you Friday night. We told you Friday that tonight we would go inside the 2009 recorded statement that the jury sat with for most of day 5. Tonight is that breakdown. The gun, the car, the shots. Keefe D's account as it was played for the jury.
And in Texas, the trial court ruling is in. On Saturday, August 22nd, the judge denied Karmelo Anthony's motion for a new trial. His conviction, a 35-year sentence, will remain in place while his attorneys pursue appellate review. We have the ruling, what the motion argued, and what comes next. That is all in the particulars. Let's get into it. All right, now some quick housekeeping. Follow us here on TikTok. Subscribe on YouTube for the replay. Coffee and Sticker Mule are in the link tree. Are you ready to do this?
Let's go. Trial watch. Commonwealth versus Lindsay Clancy, day 19. Backstory. Okay, so on January 24th of 2023 in Duxbury, Massachusetts, 3 children, 5-year-old Cora, 3-year-old Dawson, and 8-month-old Callan Clancy were killed inside their home. Their mother, Lindsay Clancy, a labor and delivery nurse, was found beneath a second-story window with life-threatening injuries. She survived and is paralyzed from the waist down.
Clancy is charged with 3 counts of murder and has pleaded not guilty. The defense does not dispute that she killed her children. The contested question is criminal responsibility. The defense argues she was suffering from severe postpartum psychosis and was not legally responsible for her actions. The Commonwealth says she acted intentionally and with malice.
So before we go further, a content note. Testimony in this trial includes detailed clinical discussion of suicide, filicide, and postpartum mental illness. If you or someone you know is struggling, the 988 Suicide and Crisis Lifeline is available by call or text 24 hours a day.
When we left you Friday, the defense had rested after Dr. Philip Resnick testified that Lindsay lacked criminal responsibility because of postpartum psychosis. The Commonwealth began rebuttal with psychiatrist Dr. Avram Mack, but his cross-examination was unfinished when the court recessed. Day 19 began with Kevin Reddington continuing that cross by Zoom.
So Reddington began this morning testing Mack's experience in criminal responsibility cases. Mack estimated that he had testified on criminal responsibility only once or twice before, making this approximately his 3rd such case.
The cross then moved through prior matters in which Mack had offered expert work, including a Florida federal case involving drug testing for temporary assistance for needy families. Reddington pressed whether courts had criticized the fit between Mack's expertise, his research, and the opinions he offered. Mack repeatedly disputed Reddington's characterizations or said that he did not recall the precise ruling language.
Mack evaluated Lindsay in April of 2026, more than 3 years after the deaths. Before the evaluation, he had reviewed extensive records and reports from defense experts, including Resnick, Spinelli, and Zeisel. He and Dr. Heilbrun interviewed Lindsay together on the first day for approximately 4 to 5 hours. Heilbrun returned for psychological testing the following day.
Reddington also asked about Mack's forensic income. Mack said it has ranged into several hundred thousand dollars in some years. That led directly to confirmation bias. Beginning with an expected conclusion that in gathering information that supports it. Mack agreed that confirmation bias is a recognized concern, although he denied entering the case, hoping to help the prosecution.
So that answer actually matters beyond this witness. Confirmation bias can affect a prosecution expert, a defense expert, an investigator, or us as viewers. The question is not simply who retained the witness. It is whether the method and the underlying record support the conclusion. So one moment worth highlighting, Reddington walked Mack through defining confirmatory bias, beginning with an idea of where you're headed and gathering information that supports it. Mack provided that definition himself on cross in this courtroom. Reddington's implicit argument was that the framework applies not just to this expert, but to the investigation from the start. That argument is for the jury to weigh.
So now let's talk about the MMPI, the K scale, and malingering. Reddington questioned Mack about the MMPI, a standardized personality assessment, and its K scale. Mack explained that the scale is designed to identify how a person presents themselves in answering. The questioning became tense when Reddington told him, quote, "What are you smiling for? This is not funny, sir," end quote. The objection was sustained.
The substantive point that followed was significant. Mack acknowledged that Heilbrun's MMPI testing did not show Lindsay lying, malingering, minimizing, or faking. Mack nevertheless said the MMPI does not, by itself, determine whether someone is lying.
Now let's talk about the diagnosis: depression, bipolar disorder, and postpartum timing. Mack maintained his diagnosis, a major depressive episode as part of a major depressive disorder, with a possible anxiety disorder, and agreed Lindsay had a mental disease or defect on January 24th, 2023. But his opinion remained that she retained the capacity to appreciate the wrongfulness or criminality of her conduct.
Reddington contrasted that opinion with bipolar diagnosis elsewhere in the record. Mack acknowledged that Heilbrun diagnosed bipolar 2, Resnick diagnosed bipolar 2, and that Spinelli diagnosed bipolar 1. Mack did not adopt those diagnoses and continued to say he found no evidence of psychosis in the medical records he reviewed.
A lengthy dispute followed over postpartum terminology and timing. Mack repeatedly returned to the DSM framework and the timing of its peripartum specifier. Reddington pressed whether postpartum depression or psychosis can emerge months after birth and challenged Mack's limited familiarity with postpartum specific tools and programs, including the Edinburgh Postnatal Depression Scale and Massachusetts MCPAP program.
Reddington pressed Mack on Lindsay's current status at Tewksbury State Hospital. Mack acknowledged that one diagnosis there is adjustment disorder. Reddington pushed whether her current diagnosis is in fact bipolar disorder. Mack responded, quote, "That may be among their diagnosis," end quote. That is the Commonwealth's rebuttal psychiatrist on cross, acknowledging that bipolar disorder may be among Lindsay's current documented diagnosis at Tewksbury. Reddington returned to a credibility point from Friday's session. Whether Mack had incorrectly described an episiotomy as simply a tear. So on day 19...
Do we have to talk about this?
It's already been brought up in the chat. I got to give the people what they want.
I know.
On day 19 cross, he asked whether anyone had corrected Mack over the weekend. Mack said he did not remember his deliberate exact wording, and no one had spoken to him about it over the weekend. Then there was a whole, what exactly is it, and a breakdown about that. And
ultimately, Reddington just tried to catch him on a previous testimony where he said this is a matter of fact, which wasn't fact.
What the point of the whole thing was a credibility thing.
Impeach him. Yes, he said something on the stand that wasn't a fact, and he
but
tried
he's
to
a
point
doctor.
that out. I understand that, but
that was the whole point. Like we are asking the jury and presenting this as a rebuttal witness, and we're saying this is a doctor with certifications, yet some things we don't know. Which I will say, maybe now all doctors technically do rotations, so to speak, in their clinicals. However, if he is a doctor of psychiatry,
yes,
he doesn't necessarily specify, which that kind of point was made, that he didn't necessarily have a lot of interaction with postpartum women, things like that. Mack said he had no opinion on whether Lindsay received good medical care from her treating providers. He did agree that thyroid testing can be important when evaluating mood symptoms, while explaining that blood testing depends on the medication and the circumstances. Reddington then ended his cross with a final line, quote, "I don't care. That's all I have. Thank you, Judge." End quote.
On redirect, Buckingham emphasizes that Mack was conducting a forensic evaluation directed to Lindsay's mental condition on January 24th, 2023, not treating her as a patient. Also, she revisited his connection to Park Dietz, why Mack and Heilbrun attended the evaluation together, and the prior Florida matter. Mack said the two experts went together because they had only one opportunity to conduct the evaluation.
The evaluation was recorded with two videographers present, and the interview recording was identified in court as what appears in our notes to be Exhibit 292. After a brief recross, Mack was excused and the court took its morning break.
After the break, the Commonwealth called Dr. Heilbrun, a forensic psychologist and professor who also works through two clinical practices. Sprague conducted the direct examination.
Heilbrun drew an immediate distinction between treatment and forensic evaluation. He would not call the person being evaluated his patient, and he would not perform a forensic evaluation on one of his own treatment patients. He estimated that he has testified approximately 330 times and said roughly 75% of his criminal responsibility testimony has been on behalf of the defense.
Yeah, he also acknowledged retention bias, the risk that an expert may be inclined toward the side that hired them, and said he tries to guard against it. His curriculum
vitae
was admitted as Exhibit 293.
Heilbrun said he spent roughly 180 hours on this case. He met with Lindsay across 3 days in April of 2026, totaling approximately 10 and a half hours, and spent another hour and a half on collateral interviews. He interviewed Patrick Clancy and Patrick's mother, Sue. He requested an interview with Lindsay's sister, but she apparently declined. He did not request an interview with Lindsay's mother.
Heilbrun said he and Mack independently prepared their own reports and analyses. They did not reach the same diagnosis. Heilbrun diagnosed bipolar disorder, while Mack had diagnosed a major depressive episode within major depressive disorder.
So Heilbrun described Lindsay's mental health history before 2022 as fairly limited. He identified anxiety connected to nursing school, case presentations, pregnancy, returning to work, and leaving her children. He said she had approximately 6 months of treatment for anxiety during nursing school and reported no adverse childhood experiences on the assessment he referenced.
He then walked the jury through the period after Callan's birth. At approximately 12 weeks postpartum, Lindsay was anxious about breastfeeding. Callan not taking a bottle and returning to work. Heilbrun described worsening anxiety and insomnia after she began Zoloft. He also discussed the women and infants records, other treatment options offered there, her return to Dr. Tufts, and Lindsay's descriptions of feeling numb or like a zombie.
So Heilbrun confirmed a bipolar disorder diagnosis. He said he was careful in reaching it because the records did not contain anything that clearly struck him as mania. The precise subtype and full diagnostic reasoning should be stated only as the testimony develops. The morning notes could turn that into simply bipolar disorder.
Heilbrun then began explaining the legal criminal responsibility factors and said he had been watching for those factors throughout the evaluation. He also turned to response reliability. A person may malinger, underreport, or otherwise shape responses, and the MMPI includes validity scales intended to help an evaluator examine those possibilities. At this point, he had not yet given the jury his ultimate criminal responsibility conclusion.
When court resumed, he continued with the testing. He described Lindsay's suicide risks as very high, referenced the Beck and Columbia measures, called the January 2023 event a very serious suicide attempt, and said she remains at high risk.
And Heilbrun diagnosed bipolar II disorder, but diagnosis is not the ultimate legal conclusion. He then walked the jury through evidence he considered when analyzing criminal responsibility, including suicide risk, psychosis, command hallucinations, wrongfulness, and the ability to conform conduct to the law. His direct examination stopped before he stated a final criminal responsibility opinion.
Heilbrun identified several reasons he believed the evidence weighed against acute psychosis. He focused on the report that the command hallucination occurred only during the roughly 18-minute period in which the children were killed and did not recur. He said that pattern was possible but rare, and he regarded the timing as something that required careful scrutiny.
He also pointed to different accounts of the alleged command, the absence of reported delusions, and Lindsay's response when Patrick returned. According to Heilbrun's reasoning, a statement centered on her suicide attempt rather than saying she had obeyed a voice, cut against the command hallucination account.
Heilbrun discussed research on malingered hallucinations and described a short-lived command as potentially convenient to a culpability claim. That was his forensic interpretation, not a finding by the jury that Lindsay lied, and the earlier MMPI testimony was that the testing did not itself show malingering, faking, or lying.
On to the altruistic filicide and the religion reference. Heilbrun then discussed altruistic filicide, the theory that a parent kills a child believing death will protect the child from suffering. In that context, he addressed the phrase, quote, "Go to God, baby," end quote. Then referenced Lindsay having been raised Catholic and to having her about suicide as a mortal sin.
Reddington objected. The jury was removed. He then did something larger than objecting to one answer. He moved for a mistrial.
Reddington argued that the religion issue had already surfaced about a week earlier, when the prosecution asked Susan Clancy whether murder was a mortal sin in Catholic teaching. The court had stopped that line and instructed the jury not to consider it. He argued that bringing Catholicism and mortal sin into the case again amounted to intentional prosecutorial misconduct, and that another instruction was no longer enough.
The Commonwealth responded that Sprague had not asked Heilbrun about religion, Catholicism, or mortal sin. She said he volunteered the reasoning while explaining his analysis of moral wrongfulness. She denied intentional misconduct and asked the judge to strike the answer and instruct the jury.
So Judge Sullivan challenged the propriety of the testimony and said the expert's understanding of Catholicism was irrelevant. He declined to declare a mistrial at that time. Instead, he ordered the Commonwealth to speak firmly with the witness, brought the jury back so they would not leave for the day with that testimony unanswered, struck the religion testimony, and instructed jurors that they could not consider it.
The jury was then excused until Tuesday. Judge Sullivan said Heilbrun's direct examination would resume, followed by cross-examination. The Commonwealth indicated it may have another rebuttal witness.
So now we're going to talk about the state of the trial and the closings timeline. Day 19 ended before Heilbrun completed direct examination. Direct is expected to resume Tuesday, August 25th, tomorrow, followed by cross. And the Commonwealth indicated it may call another rebuttal witness. Judge Sullivan said he anticipated the evidence would finish Tuesday. A charge conference would likely follow Tuesday afternoon, and closing arguments and the jury charge would occur Wednesday, expressly subject to change.
So Judge Sullivan stated that Wednesday was the anticipated day for arguments and the charge, but he expressly said the schedule was subject to change. Present Wednesday as the court's current expectation, not a guarantee. So the moment we have been building toward for 19 days of trial coverage is closing arguments and the jury charge. The judge's current expectation is Wednesday, of course, subject to change. We will be here for every remaining session and walk the jury instruction framework when Sullivan issues the final charge. Evidence of the night time.
All right, Friday night we told you, Monday we break down the recorded statements. We told you the jury had spent most of day 5 listening to Keefe D's 2009 voluntary LAPD interview. Now remember, we're talking about the Keefe D case right now. We're off of Lindsay Clancy, so
momentarily
stay with us just for a minute. Tonight we deliver that breakdown, but first the case, because if you just joined us, you need to know what this trial is.
I promise, follow along. It's going to make sense, okay? On September 7th of 1996 in Las Vegas, Nevada, the night of the Tyson-Seldon fight at the MGM Grand, rapper Tupac Shakur was shot multiple times while riding in a BMW driven by Death Row Records CEO. It's Sugar. No, right?
Suge.
I can't say it. Suge. Suge Knight.
It's Sugar.
Sorry. Tupac was struck by 4 bullets. He died 6 days later on September 13th, 1996. He was 25 years old.
For nearly 3 decades, the murder went unsolved, officially. In 2023, Las Vegas Metropolitan Police Department arrested Dwayne Keith Davis, also known as Keefe D, a Compton Southside Crips gang leader. Davis is charged with first-degree murder with the use of a deadly weapon. Born in June 1963, Davis is 63 years old. He is the only person who has ever been charged in Tupac's murder.
So Davis has spoken publicly about that night for years, in police interviews, in a 2019 BET documentary series, and in a book. His public statements became evidence against him. The prosecution's theory, Davis was in the white Cadillac behind the BMW that night. He provided the gun that was used to shoot Tupac, and his nephew, Orlando Anderson, pulled the trigger.
All right, so what the jury has heard. The trial began in Las Vegas with Judge Carly Kearney presiding. Week 1 ran Monday through Friday, 5 days. The prosecution is presenting its case in chief.
The state built its foundation across the week. Multiple witnesses placed Davis and his group in Las Vegas that night, at the fight, in the hotels, and on the Strip. The state called eyewitnesses who were at the MGM Grand when the earlier confrontation happened that put everything in motion.
The confrontation at the MGM Grand earlier that evening, before the shooting, Orlando Anderson was involved in an altercation with members of Death Row's entourage inside the hotel. That confrontation is central to the prosecution's motive theory. It is the trigger.
In days 3 through 5, the state called witnesses whose names appear in the court record, a witness named Wade Lee and witnesses named Denvonta Lee and Leonard Jefferson, who told the jury he was at the MGM lobby that night, came from Los Angeles for the Tyson fight, and was staying at the Monte Carlo.
The state also called Mario Diaz on day 5, and the witness the jury did not finish hearing from by Friday, Michael Dorsey. Dorsey continued into today, day 6.
So one unusual feature of this case is Davis's participation in the 2018 BET documentary series Death Row Chronicles. On day 5, the state called the series director and showrunner Mario Diaz. Diaz testified that Greg Kading, a former LAPD detective, and filmmaker Michael Dorsey had been retained as consultants before Diaz joined the project. Davis and Suge Knight had also agreed to participate.
Diaz testified that Episodes 5 and 6 alternated between interviews Diaz conducted with Davis and audio from Davis's 2008 law enforcement interview. The recording admitted as Exhibit 117 and played for the jury on day 4. During Diaz's testimony, clips containing Davis's face or voice from episodes 5 and 6 were admitted as Exhibit 123. Diaz testified that the series alternated between the interviews he conducted with Davis and audio from the 2008 interview. He also testified that after the series aired, Las Vegas Metro requested the raw footage, but at that point, BET provided only the material that had aired publicly. Diaz later said the raw footage still had not been produced to investigators.
So now here is the one the jury sat with for most of the afternoon on Friday, Exhibit 118, the 2009 voluntary statement that Davis gave to LAPD. This was one that was played in court in full.
The statement begins with investigators identifying themselves, LAPD Detective Long and Detective Dupree, along with Las Vegas Metro PD. Davis's attorney, Ed Wayne, is present. The date, September 9th, 2009, 12 years after the murder. And Keefe D is sitting across from detectives with a lawyer, and he starts talking.
Pay close attention to this sequence because it is the prosecution's evidence of how the gun got from point A to the BMW that carried Tupac Shakur.
In the 2009 statement, Davis described a man referred to in the case as Zip, Eric Martin, also known as Bosnip, a New York associate. According to Davis's account, before the shooting, Zip opened a concealed compartment in his vehicle and produced what Davis described as a .40 caliber Glock.
According to Davis's recorded account, Zip gave him the gun and used language Davis interpreted as an offer to help against death row's entourage. Because the available auto transcript is not a certified transcript and the exact wording has not yet been checked against the video, we're paraphrasing that exact exchange.
And Davis said he left Zip's Mercedes with the gun and passed it to the white Cadillac. At first, he said he didn't know precisely whom he'd handed it to. Moments later, however, he specified that he handed it to Big Dre, DeAndre Smith. Davis said he did not say anything to Smith when he passed him the gun.
So the white Cadillac was a four-door rental Davis says came from LA. In the recording, Davis described who was in that car: his nephew, Orlando Anderson, referred to as Lando, a person called Big Dre, and a person called T. Brown.
Davis identified Orlando Anderson as his nephew and placed him in the white Cadillac. According to Davis's recorded account, the Cadillac pulled alongside the BMW carrying Tupac on Flamingo Road. Davis then described Anderson leaning from the rear passenger area and firing across DeAndre Smith towards the BMW. That is Davis's account as played for the jury, not an independent finding by us.
Davis estimated that Orlando fired 5 or 6 rounds in roughly 3 to 4 seconds. He described the weapon as a black semi-automatic .40 caliber Glock, while acknowledging that his identification of the caliber came from newspaper reports. He said the slide did not remain locked back, which he understood to mean the gun was not empty.
And the auto transcript becomes garbled when Davis describes what he saw inside the BMW. So we're not quoting it. In substance, he described a person moving or ducking toward the back seat and said he believed Suge Knight had been struck in the head and might be dead.
How fast? Davis told detectives 5 or 6 rounds in approximately 3 to 4 seconds.
So after the gun on the tire, according to Davis's recorded account, after the shooting, the white Cadillac went to a parking lot near the Monte Carlo and he walked away. The investigators asked about the gun. Davis placed it on the front passenger side tire of the Cadillac. We are paraphrasing the exchange because its exact wording still requires comparison with the court video.
Orlando Anderson, Davis said, came back about 20 minutes later. He did not tell Davis where he had gone.
And now on to the Puffy allegation. In the recording, investigators also asked Davis about motivation. Who wanted Tupac dead? And Davis raised the name Puffy, Sean Combs, referencing him as someone who was afraid of Suge Knight.
Davis also alleged that Sean Combs, then widely known as Puffy, had made a statement in a crowded room expressing a desire to have a rival killed. Davis did not identify a specific dollar offer in this portion of the interview. This is Davis's allegation from the 2009 statement. It is unverified and contested, and Combs has not been charged in connection with Tupac Shakur's murder. So our read on what this recording means as evidence: the prosecution case rests significantly on Davis's own words. He put himself in that car. He described passing the gun, and he described watching Orlando fire. He described the gun being left on the tire. The defense can respond by arguing he was lying, embellishing, or that he wasn't there at all, but the jury has now heard his voice saying these things in a police interview room with a lawyer present in 2009.
So what's happening right now? Right now, Pacific time, day 6 is underway in Las Vegas.
Which it may be wrapped now.
3 hours ago, it's probably wrapped. That's 7:14 p.m. So I'm sure they're wrapped up. But Michael Dorsey, who did not finish Friday, is still on the stand. Again, we checked all of this is back from when we checked all this
At 5:30.
At 5:30. So bear with us. The state is continuing to call witnesses from the Compton gang world, survivors of that era.
So multiple outlets were reporting at that time that Tupac's last words, what he said after being shot, came up in testimony today. I don't have that yet. I'm still working on that. I was doing a lot in regard to the Clancy case, so we will continue our coverage on that day 6 on Wednesday, but we will continue to push that as we get it and get it processed. We will move on to Legal Minute, which is the Karmelo Anthony case. So we are in McKinney, Texas, in Collin County. In June, Karmelo Anthony was convicted of murder, not first-degree murder, which is not the Texas offense label, and sentenced to 35 years for fatally stabbing 17-year-old Austin Metcalf at a high school track meet in Frisco in April of 2025. Anthony was 17 at the time and is now 19.
Episode 21, our last episode, we told you the motion for new trial was pending. We did not guess the outcome. On Saturday, August 22nd, the ruling came in. Retired Judge Michael Chitty, the judge assigned to hear this motion after the original trial judge, Judge John Roach Jr., was recused, denied the motion for new trial. The conviction stands. The 35-year sentence stands.
So the motion for new trial raised several grounds. At the hearing, Anthony's former attorneys took the stand. They testified about a dispute central to the motion, the question of whether Anthony should have testified at trial. The attorneys involved in that decision appeared as witnesses.
And Fox News specifically reported that the new trial motion raised the issue of the decision about whether Anthony would testify, and that his former counsel testified at the hearing about that decision. So what a motion for new trial is, let's define that real quick. A motion for a new trial is a post-conviction request asking a judge to set aside a verdict and order the case retried. The burden is on the defendant to show that errors at the original trial were sufficiently prejudicial to warrant starting over. It's a high bar. When it's denied, as it was here, the conviction stands.
With the motion denied, Anthony's attorneys have said they plan to appeal, according to the Associated Press. An appeal does not automatically start the trial over. The appellate court reviews the existing record for claimed legal error.
And the motion for new trial hearing created a fuller trial court record concerning Anthony's decision not to testify, and the parties disputed pre-trial understanding about excluded evidence. Those issues may become part of an appeal, but we will wait for the actual appellate filing before predicting what claims the defense will rise.
And now, before we close, tonight's red flag. The moment religion entered the Clancy courtroom for the second time, and what the defense put on the record about it. Tonight's red flag is the religion issue. Not because every mention of faith is automatically forbidden, but because this jury heard Catholicism and mortal sin entered a criminal responsibility case for the second time after the court had already stopped the subject.
Massachusetts Guide to Evidence Section 610 says religious beliefs or opinions may not be used to attack or support a witness's credibility. That rule is narrower than a blanket ban over every religious reference. Here, the analysis also involves whether the testimony was relevant, whether its prejudicial force risked overwhelming any legitimate probative value, the earlier warning, and whether the judge's instruction could cure what the jury had heard.
So the first time, Reddington objected and accepted the court's forceful instruction as sufficient. The second time, he argued that the repetition changed the equation. He made a contemporaneous objection, identified the earlier incident, alleged misconduct and prejudice, requested the strongest remedy, a mistrial, and received an adverse ruling on the record.
That matters if there's a conviction and an appeal. An appellate court generally needs a developed record. What happened, why counsel objected, what relief counsel requested, how the other side responded, what the judge ruled, and what corrective action followed. Reddington supplied that for the record today.
So, preserved does not mean won. Obviously, as we've seen, They are continuing the case tomorrow. And I continued to try to pull the docket today because I wanted to be able to verify to you that it is on the docket. And as the last I pulled, none of today was on there in regard to this motion. So our read, Reddington has been disciplined all trial about stating objections and grounds for the record. Today's mistrial motion was the clearest example. He was not merely reacting in the moment, he was preserving a defined issue so that if the verdict requires appellate review at a later time, the record will not say the defense stayed silent or accepted the cure. Whether an appellate court would agree is a separate question, but the issue is now built into the record.
And that is the red flag. Once a court has already warned the parties away from a loaded subject, its return carries more weight than the isolated words alone. The judge chose a curative instruction over a mistrial. The jury must follow that instruction. The appellate record now preserves the defense's argument that the bell could not be unrung. That is where the particulars stand tonight. If this is your first time here, we teach from the public record. We tell you what is confirmed and what is not. And we never pretend a headline is a fact.
3 things to watch this week. First, Lindsay Clancy. Heilbrun's direct resumes tomorrow morning, followed by cross. The judge currently anticipates arguments and the charge on Wednesday, subject to the next court date. The defense has now preserved a mistrial issue for the record, which was our red flag. Second, Davis, we will confirm the next court date and bring you the day 6 breakdown on Wednesday. And third, Karmelo Anthony, watch for an appeal filing. We'll track it.
Thank you guys for the follows. Thanks for the likes. Again, follow us on TikTok and subscribe on YouTube so you never miss an episode. Coffee and Sticker Mule are in the link tree in our bios.
I appreciate you all being here. I genuinely do. And we want to keep doing what we're doing. So because tonight's episode did include discussion of the deaths of children and violent crime, we want to leave this here with you. The 988 Suicide and Crisis Lifeline is available by call or text anytime, 24 hours a day. This has been our opinion,
our analysis,
not legal advice.
Headlines end.
The details begin. We will see you Wednesday night, 9 p.m. Eastern Time, for our next episode of the Casewalker Chronicles, The Particulars. We'll see you guys Wednesday. Thank you guys so much. Have a great evening and a great week.